있거든요. 이것도 꼭 읽어보고 하세요. 이거는 시험 문제에 꼭 나올 겁니다. 여러분들한테 케이스 주고 브리프 하세요. 이렇게 꼭 나올 겁니다. 꼭 해보시기 바랍니다. 엑서사이즈 다 하시고요. Let's look at page 85. Harrington versus Taylor. Okay. What happened in this case? So defendant had assaulted his wife, okay, who took refuge in plaintiff's house. The next day, defendant gained access to the house and began another assault upon his wife. Defendant's wife knocked him down with an axe and was on the point of cutting his head open. There, plaintiff intervened. Plaintiff was the wife's friend, okay? But the wife's friend caught the axe as it was descending. So the friend basically blocked and suffered instead the injury that the defendant would have received. So defendant orally promised to pay the plaintiff because why? Because he studied all this, right? He was the wife beater and he studied all this situation, and wife's friend was there to save him. But nothing, no payment was made by the wife beater to the wife's friend. What happened in the lower court? Who won? The wife beater or the wife's friend? Wife beater. How did they win? Was there a trial or no? Was there a trial? Was there a trial? No, right? How do you know? Demurrer was sustained, right? What is demurrer? What is demurrer? What does demurrer mean in French? You don't have to know any other French word, okay? But you have to know this one. What does it mean, demur? Demur means come on. You can look it up right now. What does demur mean? No. So what? Right? That's what demur means. So plaintiff, says these and those things in the complaint, and defendant goes, so what? Okay, so what? All of that is true, right? So when the defendant demurs, he is not raising a factual dispute. He is not disputing the version of the facts that plaintiff alleges. The defendant is accepting. So the defendant is raising no objection to the facts alleged by the plaintiff. But defendant is saying, even if all of that is true, I still win. That's what demurrer is. Okay? All right. Okay. Is there a consideration in this case? No, right? Because it was voluntarily performed, right? I mean, there was no give and take. There is no, I mean, physically it was impossible to really, I mean, consideration means some physical, some monetary, some financial value, or even psychological value, some value to be exchanged through the contract. But, you know, plaintiff acted in a split of a second. Didn't have any chance to really talk about the value or think about the value. So here the defendant makes a promise to pay, right? The question is whether that promise to make the payment is a valid contract, right? Not whether the plaintiff's act of blocking the acts gives rise to a binding contract, but the defendant's promise of payment after the accident, whether that promise becomes a binding contract. Is there a consideration for the defendant's promise? No. Okay? It's like, you know, me promising one of you to give $1 million for no reason on January 1st. And I told you that promise is not binding if there is no exchange, if there is no exchange of value for giving that $1 million. Okay. Let's look at the next case. Rose versus Elias. Okay. All right. So here, defendant, a married man, has promised to buy plaintiff, a single woman, an apartment. The question is whether there was consideration for that promise. And she's saying she gave love and affection for the prior 3 years, and that should be sufficient consideration for his promise to become a binding contract. What does the court say?
Circumstances presented suggest adultery and thus illegal consideration.
Okay. So the court is saying that, hey, the relationship was sexual, and if you look at the ending part of paragraph 4, it says, love and affection in the circumstance presented suggest adultery and thus illegal consideration. Since there were found to be no severable legal component of the consideration for the defendant's crimes, the court correctly ruled the alternative that contract was void as against a public policy. Okay. Also, apparently there was another argument made by the woman. If you look at paragraph 3, like six lines down, it is apparent that the parties did not view plaintiff's forbearance from accepting job opportunities as a consideration for the promise. Okay, so it's not like he said, I'll buy the apartment if you do not seek a job, right? So apparently she made that argument as well. But how about, why is the court talking about, the sexual relationship? And how that can be an adultery? And therefore, it's illegal consideration. And do you agree with this assessment? By the way, this case was decided in 1991.
Is adultery illegal?
Adultery is not illegal in any state of the United States.
How about then?
1991. As far as I know, it has been legal for many, many years. Is adultery illegal in Korea? Not any longer, after the unconstitutionality decision a couple of years ago. So, does this make sense? That now, if you read the very last sentence, the court correctly ruled in the alternative, right? In the alternative. In the alternative means 그러니까 주의적으로라고 하고 또 주의적으로 아니면 그 다음이 뭐지? 갑자기 기억이 안 나네. 주의적 주장이 있고 예비적 주장. 네. 그래서 이제 주의적으로 판시한 게 아니라 and the alternative. 그게 아니라면 이 love and affection이 그 love and affection에 대한 그 대가일 수도 있지만 그 love and affection이 섹스라면, 그래서 불륜이라면, 그러니까 외도라면 이건 불법이기 때문에 against public policy, 이거 이제 우리나라로 따지면 뭐 미풍양속에, 예. 그렇게 배우나요? 미풍양속에 반하는 계약은 무효다, 이런 거 배우나요? 네. 미풍양속이라는 말을 미국 법으로 쓴다면 against public policy 뭐 이렇게 쓰면 돼요. What happened in the lower court? Who won in the lower court? The man or the woman? The man. Okay. Defendant's motion to dismiss the complaint for failure to state a cause of action. This is like what in French? Demurrer. Right? This is demurrer. Because there is no factual dispute, the facts are exactly as the parties agree, but the defendant is saying, even if the plaintiff's allegations are all true, there is no valid cause of action. There is no valid cause of action. 그러니까 의미 있는 청구 원인이 없다는 거죠. 청구할 만한 법적 청구의 대상이 되는 원인, 사실 관계가 없다는 거죠. Okay, any question or comment about all these cases? 여기 계약서가 있는데 계약서는 로스쿨 1학년 때는 안 배워요. 계약법에 대해서만 배우고 계약서를 읽는 법을 배우려면 사실은 로스쿨에서는 그거 안 가르쳐 줍니다. 미국 로스쿨에서. 근데 우리나라 로스쿨에서는 가르쳐 줘요. 제가 가르쳐 드려요. 영문 계약 실무 과목에서 계약서 읽고 수정하는 거는 배우면 되기 때문에 그 다음 케이스는 보지 않아. Any question or comment about these cases? If you don't, since we have more time, I asked you to read these other contract cases. So let's talk about them. The one that is placed on the blackboard. So let's start with Martinak versus Bakovic, the case from 1930. Okay. Now you have to read the real case. Okay, what happened in this case? Okay, simply what happened? It's a contract about construction of fishing boat, right? And fishing boat was not delivered on time. Right? And the fisherman who was to use the fishing boat is suing for what? Well, what happened in the lower court? So if you look at the second page, the second paragraph, okay, read carefully. It was provided that said boat would be delivered to defendant on May 1st, 1927, but the same was not completed until May 30th, 1927. So how much time did the fisherman lose? About 29 days, right? Okay. And defendant lost the use of the said boat for said month and was damaged on that account in the sum of $1,500. The cause was tried to a jury, which found for the plaintiffs. So plaintiff, the fisherman, won against the defendant Kuocw, who appeals from the judgment entered on the verdict. Okay. Appellant assigns as error the sustaining of objection to the following offers of proof. Okay, what offer of proof? Offer of proof는 이제 뭐를 입증하겠다라고 이제 얘기를 하는 건데요. The reasonable charter or rental value of the boat of the type of the one in question was $1,000 a month, reasonable charter value, rental value, which was the loss sustained by the appellant during the month of May. The amount of money the boat would have earned in addition to what it did earn had it been delivered May 1st instead of May 31st. There was a demand for boats of this time during May 1927, and in around Seattle, Tacoma, there was a demand and ready market for such boats for each day of the fishing season in and around Puget Sound and in Alaska. Okay. And the question is whether, okay, well, I guess we have to read the second full paragraph as well. The contract provided that the boat should be completely delivered to the appellant by May 1st, 1927. The evidence is conflicting as to the date of delivery. There was testimony supporting the position of a respondent that delivery is effect 2 weeks subsequent to May 1st. The failure to deliver on the day stipulated in the contract was because of changes in the construction made at the request of the appellant. The appellant testified that he accepted the delivery May 26. He also testified that he estimated the loss by reason of the delay was $500. That the fishing season only lasted 4.5 months, and he caught $475 worth of fish the first day that he fished. He estimated he was damaged $500 by reason of his failure to arrive on the fishing grounds in time to look over the place, locate his lines, and things of that nature. That he figured he could make about $50 a day, a profit, while using the boat in those waters. So he figured he could make about $50 a day profit. So that's 26 days, and I mean 29 days times $50, so $1,500, right? That's what the plaintiff asked for, and that's what the jury gave to him, right? And the question is whether the fisherman can receive all that $1,500. And we learned a similar case like this during my lecture, right? What was it? Do you see that? What's the name of the case? Hadley versus Baxendale, yes. In Hadley versus Baxendale, you remember the case, and so if you follow Hadley versus Baxendale, should the fisherman be entitled to all the $1,500? Or how much should the fisherman be entitled to? Did you catch that? Yes, $1,000, right? Because the fishing boat could have been replaced with the rental. Okay, but still, the appellate court says, oh, the trial court still, rejected the offer of proof correctly and affirms the trial court decision, right? Why is that? Okay, so the cause was tried to a jury which found for the plaintiff against the defendant. So the fisherman won $1,500, and the defendant, Kuocw, the maker, argued, offered to prove that, rental value was $1,000, right? And therefore, according to Hadley versus Baxendale, it should have been only rental value that fisherman is entitled to, right? That's what he offered to prove, but the court said, oh, you don't have to prove that. offer of proof는 뭐냐면 이제 그런 거예요. 그 재판을 할 때 내가 이것을 입증하겠습니다. 이것을 위해서 뭐 증인을 불러오겠습니다라고 얘기를 하면은 판사가 아 그거는 의미가 없으니까 안 해도 된다라고 이렇게 거절할 수가 있거든요. 그래서 이제 그 거절을 했는데 근데 헤들리 vs 백슨데일에 따르면은 매우 중요한 증거잖아요. 1000불만 쓰면은 다른 배를 불러다가 그 조업을 할 수 있었다는 건 매우 중요한 증거인데 왜 이 케이스 제일 뒤에 가면은 The offer of proof made in this case at bar disclosed the evidence sought to be elicited was not relevant to the issues. Therefore, trial court correctly rejected the offers. 라고 하면서 원래 사건대로 그러니까 1심 판결을 그대로 승인을 하죠. 왜 그럴까요? 그렇죠. 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 If you look at paragraph, page 3, right? Look at page 3, the sixth line, the special circumstances under which the contract was made were communicated to the respondent. What special circumstances? The contract with Atlas Packing, right? 이게 왜 아틀라스 패킹이라고 하냐면 물고기를 가져오면 통조림에다 이제 집어 넣어야 되잖아요. 패킹을 해야 되죠. 네. 그래서 수산물 유통업체들 이름이 패킹. 음료수 유통업체들은 그래서 바틀링 컴퍼니라고 많이 하죠. 그래서 코카콜라 바틀링 컴퍼니. So anyway, both parties admit that the boat was to be constructed for the purpose of fulfilling the terms of the contract between the appellant and Atlas Packing Corporation. The damages recovered for the breach of the contract are such as might reasonably supposed to have entered into contemplation of the parties when they made the contract. Right? So Hadley versus Baxendale rule applies here or doesn't apply? Does not apply, right? Hadley versus Baxendale rule can be distinguished because here is a special circumstances, right? This is something that you ask during class. Some of you ask during class. Then, right, you asked whether you can avoid the application of Hadley versus Baxendale, the consequential damages rule, if the parties sufficiently communicate, right? If the party sufficiently communicate to the other party the specific use, the contract, the specific use, the contracted part or the contracted equipment will be used, right? All right. Other cases are like this, okay? Daly versus Isaacson, 1952 case. Okay, what happened here? What's the case for? What's the contract for? Delivery of millwork, right? millwork는 mill은 이제 뭐 엄청나게 빨리 돌아가는 걸 그냥 다 mill이라고 해요. 그래서 millwork라고 하면 뭔가 이제 갈아서 만드는 거. 아마 이제 금속 부품일 것 같아요, 제가 보기에는. It was a contract about delivery of the millwork, and what happened in the lower court? Well, it's all in paragraph, right? So defendant was the primary contractor, right? Defendant was the millwork vendor. vendor 이제 하청업체 vendor라고 하죠. Plaintiff was the primary contractor, and primary contractor could not finish the housing project contract. could not finish the housing project because the millwork was not delivered on time. And if you look at page 2, about 6 lines down, 6 paragraphs down, the court says the trial court allowed $12,000 damage to Delhi for the delays in delivery and defective materials based on its showing that the showing of the extra labor cost these had caused. This amount being well within the evidence is sustained plus $1,777 for additional supervisory overhead expenses incurred after termination of the contract, which would not have been necessary had the proper quality materials been furnished. And the court says on page 3, Isaacson knew the terms of the contract that Delhi had with the Army engineers. His own contract with Delhi was to furnish the millwork according to the specification for the particular project. He must therefore have known that the defective material would require extra labor in order to secure the approval of the Army engineers, which was indispensable. He knew that it was not in Delhi's power to accept and use inferior material or to take longer than the prescribed time for the completion of the project. Okay, and the court affirmed the extra labor cost that the primary contractor, Delhi, incurred. Okay. This is not about the value. This is not about loss of profit, but this was a lawsuit for extraordinary labor cost that the primary contract suffered, right? Because the delay was made. Probably the vendor, millwork vendor, was arguing, "Hey, I didn't know that, primary contractor will hire some other extra labor for that high a price. We cannot be responsible for that." But the court is saying, hey, the primary contractor, 원청업자죠, primary contractor had contract with Army engineers. They had to hire some extra labor to meet the deadline. Okay. All right. So the third case, the two other cases are similar. It's all about consequential damages rule. So read them yourself, and you'll see that the cases refer to one another. One case becomes precedent for the other. So if you read in a row, you will kind of see how the cases develop. Okay. All right, now you became an expert in contract law. Now you can do the quiz next week. Okay, so be ready for Rainmaker, and it will be like the first quiz. Okay, question, comment? All right, we'll end today. Thank you, and good luck next week.